Well, look, welcome everyone, and a huge thank you for joining us today. I'd like to start by acknowledging the traditional owners of the land on which we meet today and pay my respects to elders past and present. For anyone who joined us last year, you'll know that Cilla's HR Horrors was a huge success, and we're excited to be back for another year. We're always delighted to partner with Cilla and Clayton Utz, so I'm just very pleased that she's back again, and thank you again, Cilla, for running the session. For those who I don't know or haven't met, I'm Angela Franks and run the Fraser Jones practice in Australia. We're a dedicated and specialised HR and health and safety recruiter. We're a global business, but we have locally offices in Sydney, Melbourne and Brisbane, and we service clients all over Australia. So the session today is broken into two key sections. So Cilla will start by updating us on recent and sort of topical employment law updates. I think there's quite a few. And she'll cover things like the Job and Skills Summit and the Respect Work amendments. Then we move on to the HR Horrors bit, where we will talk about sort of that common pitfall areas for HR. And I think we're going to spend a bit of time on performance management today. So to that end, I'm absolutely delighted to introduce Cilla. Cilla's the partner at Clayton Utz, specialising in workplace relations, employment and safety. So as Cilla's presenting, please feel free to ask questions in the Q&A. So I'll monitor them. Everyone's on mute, so if you can communicate through that box, and then we'll go through questions at the end. The session's recorded and the link should be available in about a week's time. It's sent to our team who top and tail it and make it look pretty. So over to you, Cilla, and I will turn my mute.
Thanks, Ange. And while you're doing that, I'll share screen. So can everybody see the slides on the screen? Excellent. Ange can. So look, thanks for having me back again, Angela and Fraser Jones. There certainly have been a lot of HR horrors over the last 12 months. So it was hard to work out a specific topic to discuss. So we'll start off though, as Angela mentioned, with a bit of a highlight of some things that are occurring that are really impacting on employment law and HR. So first one is Jobs and Skills Summit. Second one is the post Respect at Work report and the positive duty that is coming up. Then we'll move to the HR horrors. I've got a bit of a focus on performance improvement and PIPs, as many of us call them. There'll be some case studies, one actual case study, and then some references to some recent cases that have been interesting and impactful. And then we'll hopefully have some time for some questions at the end. So moving on to the Job Summit, I'm sure all of you have heard a lot about it. Obviously, the Job Summit was led by the PM and the Treasurer, and there were some key focus areas of the Job Summit that I thought it was worthwhile just mentioning today. And they are enterprise bargaining, boot changes, so that's a better off overall test, and also flexibility. So I'm not sure if those who are on the call, whether you've got enterprise agreements within your workplaces, but one of the most important takeaways from the Job Summit is really about proposed changes to how enterprise agreements will be renegotiated in the coming years. And really we're seeing quite a changed environment being foreshadowed by the government. Unsurprisingly, with the Labor government, there is this focus on collective enterprise bargaining and essentially part of the employment law framework that really is quite beneficial for the union movement. So the Workplace Relations Minister Tony Burke announced that the government was committed to reform in this area, and the most significant reform that is being proposed is reform to multi-employer enterprise bargaining. And essentially this change is going to allow two or more employers to come together in the context of enterprise bargaining. So it's really going to increase the focus and the impact that unions can have on multiple employers at a time. So a union, for example, instead of trying to initiate bargaining with one company, could say go to 3 different companies in a sector and propose bargaining with those 3 different companies that might, for example, have similar workplace issues. So it's quite a significant change. The industry groups that spoke at the summit were quite vocal about the challenges of this reform. And we don't yet have the details of the reform, but suffice to say, the current enterprise bargaining landscape is going to significantly change. There's always an uptick in enterprise bargaining when we have a Labor government, but with this targeted reform, it will be an increasingly employee and union-friendly landscape that employers will be forced to operate in. So that's just flagging that those changes are coming. Unfortunately, I don't have the details yet. The government hasn't given us the details of what that will look like. But if you have an enterprise agreement in your workplace, there are changes coming down the line that will impact when you renegotiate, or for organisations that are looking to bargain in the next few years, those changes will impact you as well. So the boot changes, so the boot is the better off overall test that is under the Fair Work Act. And the government has also foreshadowed revising the boot and trying to ensure that the way that the boot is applied is a little bit more flexible. So there has been quite a lot of criticism of the boot being too legalistic and it being quite challenging for organisations and unions and employees to ascertain whether an agreement does pass the boot. So it kind of goes to the Fair Work Commission, and in that little mythical space, they assess whether the enterprise agreement passes the boot. So again, that is an area that we'll be looking to, and most organisations and employment lawyers like myself are actually quite encouraged by this change. Any way in which this can be simplified and make things more transparent is going to be helpful in the context of enterprise bargaining. So putting enterprise bargaining now to one side, the third area of focus of the Job Summit is on flexibility. And all of you would be aware that post-pandemic, most organisations, whether in Australia or around the world, are adopting much more flexible workplace arrangements. So this change really is about ensuring that there's more flexible arrangements available to everybody. Unpaid parental leave changes have also been flagged to the Fair Work Act, including protections from employees in relation to adverse action, harassment and discrimination as well. So recently you all, I'm sure, would have heard that the government passed an increase in terms of the phased in increase from 20 weeks to 26 weeks government-funded paid parental leave between 2024 and 2026. So already we're seeing these enhancement in government-mandated and statutory entitlements that we would expect to see with a Labor government. So there are three main changes, and increasing workforce participation is another key feature that came out of the summit. And so we are expecting to see quite directed efforts in terms of policy changes to encourage both women to re-enter the workforce, as well as increased support for First Nations people and people living with disabilities. So there's some changes that will likely impact on most workplaces in Australia. And there've also been some flag changes in relation to skilled migration and additional funding for TAFE training support. So that's a very, very quick summary of the main impacts of the Job Summit. As I mentioned, they are really looking at enhancing participation in the workforce. And on this slide, I've just got some of the key initiatives that have come out of the summit. So the Albanese government agreed to 36 immediate initiatives, and there's also been this white paper that has been released on employment. I'm not sure if any of you have read it, but it's quite a detailed document. And under each of these titles that are outlined on the screen, the government has indicated some focus areas for immediate and further work. So things to look out for, and the probably most relevant ones for me to mention today are firstly the modernising of Australia's workplace relations laws, including, as I mentioned, to make bargaining more accessible for workers and businesses. They're going to amend the Fair Work Act to strengthen access to flexible working arrangements, make unpaid parental leave more flexible and strengthen protections for workers against discrimination and harassment. As I mentioned just now, they're going to be improving access for jobs and trying to enhance the pathways to work for women, First Nations people. Regional Australia also gets a look in. I thought I saw someone may have been from Bendigo. And they've also focused on increasing accessibility for culturally and linguistically diverse people, including equity targets for training places. So that really is a significant change. And there'll also be 1,000 digital apprenticeships in the Australian Public Service and other measures to essentially reduce those barriers to employment that those minority groups quite often face. And in terms of maximising jobs, most of us have experienced the challenge that COVID has brought about in terms of, a really, really tight labour market because we don't have all of the migrant work and the temporary working visas in the country. So there will be an increase in the permanent migration ceiling to 195,000 in 2022-2023 to essentially try to ease that widespread and critical job shortages that most organisations have really felt off the back of the pandemic and that lack of movement that we would normally see and benefit from in Australia. So that was a job summit. As I mentioned, I'm doing a bit of a whirlwind tour of some of the updates, and there have been quite a few before I move on to the HR horrors. So the third one that I wanted to talk about is just the update from the Fair Work Ombudsman. So most of you would be aware that the Fair Work Ombudsman is the regulator in this space. And the FWO, as we call it, puts out an annual report. And interestingly, the 2021-2022 report demonstrates there has been a significant increase in the number of cases that the Fair Work Ombudsman has litigated. So there's been 80% more this year than they were in 2019 and 2020. Now, obviously, the pandemic did have an impact on that, but there's actually been a record number of litigations by the Fair Work Ombudsman in the last financial year, and that was 137 litigations. And in previous years, whether pre-pandemic or not, they've never exceeded 100 litigations. So the regulator is really cracking down hard. There's been a focus on large companies. There's been a lot of media, as you'd be aware, about sort of universities, big banks. So they are really back with a vengeance now post-pandemic, and they've recovered more than $280 million for many employees with respect to underpayment. So their annual report said that again, there was quite a lot of issues of focus from the Fair Work Ombudsman's perspective. So things to take away so you know that the regulator is looking at this are things like rectifying annualised salary arrangements or annualised salaries that fail to compensate staff sufficiently in terms of their minimum entitlements under the relevant underpinning modern award or their entitlements under the Fair Work Act, complying with enterprise agreements and obligations under enterprise agreements and undertakings was another focus area of the regulator, as well as recommending, the Fair Work Ombudsman has recommended that organisations really undertake quite comprehensive reviews of their HR practices just to ensure compliance and really effective governance within your organisation. And so one of the key takeouts that relates to all of these things, whether it's bargaining compliance or underpayments, is just to really invest in record keeping systems and having some expertise in auditing, as well as really solid payroll functions. So I'm sure that all of us know the benefit of having a good payroll system or not. So whether you work for a large Australian company or an international company or not, if there is a presence in Australia, the Fair Work Ombudsman really is sending a very strong message to get your house in order. Any leeway that the regulator was giving during the pandemic has absolutely gone. They are cracking down on underpayments. And of course, with the Labor government, they are very much supported to do this work. They're going to be going hard and flush with cash from the government. We actually do some work with the Fair Work Ombudsman and know that they are really preparing to go forth with quite a lot of litigation against many different companies. So if you needed a reminder to get your house in order with respect to paying people appropriately, you've now got it. So moving on to the second topic that I wanted to talk about by way of update, and that really is the changing landscape that we have now following the Respect at Work report. So I'm sure you'd have to have been living under a rock not to have heard about Respect at Work, but in March 2020, the Australian Human Rights Commission released the Respect at Work report, and that was off the back of a national inquiry that Kate Jenkins, the Sex Discrimination Commissioner, did on Australian workforces, and there were 55 recommendations, all of which were partly, wholly or partly agreed to now by the government. So since the Respect at Work report, there have been some legislative changes to the Fair Work Act and discrimination laws. So the first one was a change to the Fair Work Act that now a worker who is sexually harassed at work may apply to the Fair Work Commission for a stop sexual harassment order. So that's akin to the bullying regime that the Fair Work Commission has. So that's quite a significant change where if somebody's being sexually harassed at work, they can go to the Fair Work Commission rather than historically they'd need to go to the Anti-Discrimination Board or the Australian Human Rights Commission. Similarly, the Fair Work Act was amended to find that sexual harassment in connection with an employee's employment can be a valid reason for dismissal. So essentially, they have mandated in the law that sexual harassment is essentially a form of, serious misconduct. Shouldn't really come as a surprise to anyone, but there were people, respondents to these claims that were challenging whether if they sexually harassed someone, termination was an appropriate outcome. So they're the changes in terms of the Fair Work Act, but in late September 2022, the government also introduced changes in the anti-discrimination and human rights legislation by way of the Respect at Work bill. And so this was really the much anticipated bill to implement 7 of the remaining legislative recommendations of the Respect at Work report. So most significantly, the bill creates a positive duty for employers to take reasonable and proportionate measures to eliminate sex discrimination, sexual harassment, and victimisation as far as possible. So we haven't had a positive duty to prevent or minimise and eliminate sexual harassment, discrimination, and the like until now. That's a very significant change, and I'll come to this in further detail shortly. In addition to the positive duty that we now have with respect to minimising and eliminating sexual harassment, the bill strengthens the Australian Human Rights Commission with new functions to assess and enforce compliance of the positive duty. So the Australian Human Rights Commission has been given significant funding to essentially become a quasi-regulator to investigate these matters themselves. So that's a significant change as well. I had dinner with the president of the Australian Human Rights Commission a few months ago, and they were working through what that change was going to look like on the ground. But that again is a really, really positive step in terms of giving our sexual harassment laws real teeth and giving the Australian Human Rights Commission real teeth in terms of being able to actually manage that. Another thing that the bill has is an express prohibition on conduct that results in a hostile workplace environment on the basis of sex. So you would have heard about organisations having a hostile workplace for women, for example, or people from a non-English speaking background. So again, this bill is really putting that concept to the forefront. It also allows for representative bodies such as unions to make representations and applications to the federal court. Essentially, it's providing expressly for class action type matters in relation to discrimination proceedings. So again, a significant change, and we are seeing seeing a lot more class actions coming up in the context of employment law, where that hasn't really been a feature of Australian labour law, as distinct, for example, for our friend that's joining us from New York, with the US, which has had a lot of action in this space for quite some time. And so the last thing that I wanted to talk about in terms of the changes that are in the bill was also changing the cost protections that are in the Australian Human Rights Act, so that each party bears its own costs with respect to discrimination proceedings. So what that means is that people who have been discriminated can bring a claim and not be concerned that if they cease the claim, or if the matter settles, or they lose the matter, that they will have to pay their employer's costs. So that is, again, a significant change that really will encourage people to make sex discrimination complaints. So in terms of what we've seen on the ground, we have seen a lot of our clients, which are, large Australian and international organisations, really focusing on getting ahead of the positive duty by implementing best practice processes in relation to minimising and preventing sexual harassment in the workplace. So we're not just seeing compliance with legal issues and sort of box ticking exercises. We're seeing real proactive management, ensuring that sexual harassment is part of the work health and safety framework, and ensuring that organisations are fit to be able to discharge that positive duty to eliminate sexual harassment within their workforce. So if you haven't already started thinking about this in the context of your role as an HR advisor, then it really is time to start examining the systems and governance mechanisms that your organisations have to ensure that you're going to be well placed to discharge this positive duty that organisations have. So I included this slide, and I think, Angela, you'll probably email the slides out to everybody afterwards, or it'll be part of the video. So really, I just put this slide in there more as a point of reference for everybody to have after the session, to really have in terms of what you should be doing to discharge this positive duty that we now have with respect to sexual harassment. So essentially, the positive duty really is about ensuring that your organisation is taking reasonable and proportionate, that's the language of the Act, measures to eliminate, as far as possible, sex-based discrimination, sexual and sex-based harassment, as well as these hostile workplaces and victimisation. So as I mentioned before, we don't have a box ticking exercise where you roll out a webinar or some online training and that's going to be enough. You've now got a positive duty to be taking steps. So thinking about preventative measures, thinking about how you're monitoring sexual harassment within the workforce, having support for employees, delivering training and education regularly, rather than just a sort of every 2 years exercise where we're really just giving lip service to creating a workplace that is, friendly for women and others that might be subjected to sexual harassment. So again, I include this slide really as more of a takeaway rather than one to go through in any detail. And this is just what Safe Work Australia, which is the national safety regulator, recommends in terms of trying to prevent sexual harassment in the workplace. So some of these include, creating a safe and physical and online work environment. So with lots of people working from home a lot more now, we are seeing organisations ensuring that their online work environment is safe as well. So having surveillance, ensuring that people are working in a safe place, especially when they are working remotely, creating a positive and respectful workplace culture, ensuring that people understand what those standards are in your workplace. We did find that there was a bit of an uptick in disrespectful behaviours, whether it was bullying, sexual harassment and discrimination, when people returned to the workplace. It was like people kind of relaxed their boundaries and then they kind of let loose when they were back in the office. So we did see a bit of an uptick. So just reminding people about those expectations when they may have been feeling a little bit more comfortable at home. Of course, providing information and training. This one's really obvious. And addressing unwanted or offensive behaviour early. So what we see with these types of things is sometimes low-level behaviour is a precursor to the more significant unlawful behaviour. So if you don't action those things early, you can see real problems. And again, with this positive duty, you might get pinged by the Australian Human Rights Commission. Of course, encouraging a speak up culture so that people within your organisation will actually report sexual harassment is important as well, and really responding appropriately to sexual harassment when it occurs. So I think that's probably the most relevant part as HR professionals, that when you get these claims, you respond appropriately. So I've included here a quick scenario, and maybe, and you can get people's comments in the chat box.
Yeah.
But this was really just a scenario to get people's views because they are quite divergent. So here we've got the CEO of Crazy Cats, Joanna. She's notified by HR of a complaint of sexual harassment against a senior executive, alleging that she was touched inappropriately at a client function. Joanna wants to do something about the complaint, but thinks it's best to consult HR and public relations for specialised advice. To Joanna's surprise, the PR team advised that the complaint remains confidential and to avoid reputational damage, and that whatever happens must be strictly confidential, and there must be strict confidentiality in place. HR says you can take action where the complainant consents to an investigation, and even then, it could take weeks. Plus, the payout to terminate the senior executive's contract would be significant. Joanna decides to note the complaint, but not to take it any further. So, do people just want to make some comments in the chat box of what you think, if any, are the risks of that approach?
And just, Cilla, while they do that then, just to give people a minute, we did have one question about positive duty. One of the questions was explaining it a bit more, which you've covered, so that's great. And then another one was, will this be applied retrospectively?
No. So it's going to be moving forward. So, but essentially that's why organisations now are trying to get their house in order, because it will be moving forward. So if something has occurred in the past, you're not going to get pinged for that positive duty, but you might then still get pinged for sexual harassment or discrimination.
Okay, fab. Can you see the chat?
Enough?
Yeah, we've got.
Yep. Got a duty to take.
Yeah, here we go. Doing nothing's not an option.
Yeah, good.
Behaviour would continue and worsen. HR has a duty of care once they know about an issue.
I love
this
it.
type of a duty to take action. Sorry, as people are typing, it's moving as I'm trying to read it.
No, it's all good. I can see it. And look, I mean,
Cool.
What this shows is that this group, thank goodness, is a enlightened and informed group of HR professionals. No surprise, of course. So essentially the outtake of this case study is that former approach, which we did see quite often, of essentially dismissing the allegations, justifying someone's behaviour, that person brings in a lot of money, all of these things are no longer acceptable. There is acceptance now that of the serious impact of sexual harassment on its victims, male or female. And what we're seeing now in terms of best practice norms that are coming through is really that victims will be heard and supported by organisations. So I'm glad that everybody's on the same page in that regard. And what we're moving to is a really victim-centred and trauma-informed approach to sexual harassment. So it sounds like I'm absolutely preaching to the converted on this webinar in terms of knowing what the deal is with respect to sexual harassment, but many of you will also know that you'll have managers in the business, you might be business partners to less informed individuals. So it's not just about ensuring that HR knows what to do, it's about ensuring that your managers and other business leaders are aware of these changes so that people will take action and actually escalate it to HR, because quite often we know that by the time it gets to HR, some problematic decisions have been made. So in addition to having this trauma informed approach where we're really putting the victim at the centre of our considerations as an organisation, we're also trying to encourage our clients to really encourage bystander action so that bystanders can feel empowered to report and assist without fear of victimisation themselves or ramifications within the workplace. And of course, as you've all identified, the result of not doing anything in this scenario is, claims claims, liability, of course, bigger reputational damage than the one that the PR advisor was concerned about here, and significant penalties and damages are being awarded now in this space in line with community expectations. So I'm pleased that everybody's on the same page. I think your job is to go back and ensure that your business leaders and managers are also similarly alive to these risks, so that things don't go through to the keeper without getting your sage advice. So moving now on to HR horrors. I wanted to talk today about performance improvement plans. There's been a lot of things that have been challenging coming out of the pandemic, and we've sort of talked to death about, return to work and vaccinations and all those kinds of things, and hopefully all of that is in our past. But one of those enduring HR horrors that we find, even very sophisticated clients and HR BPs sometimes coming undone with, relates to performance management, PIPs, bullying and misconduct. And so these are sort of HR horrors that all of us can face day to day. So I wanted to just give you a bit of a quick refresher on performance management and give you some tips, I guess, on how to avoid some of the common traps that we see. And as I said, my clients are very large organizations that have big HR teams, and still things can go wrong. So hopefully I'm not going to be teaching you how to suck eggs, but just reminding you of some of those common pitfalls that we have. So the first thing that I wanted to talk about in the context of a performance improvement plan and conduct management is just really about ensuring you understand what you're actually dealing with. So where an issue arises that relates to how an employee is performing their role, it'll really be important to consider whether it's due to poor performance, a misconduct issue, or sometimes there's an underlying medical condition that can be impacting or creating a performance issue. So it is really important from the outset to draw a distinction between these cases, because there are different considerations and processes that will really inform the steps that you take when dealing with these different matters. So in terms of a performance issue, that of course is going to whether the employee can achieve the outcomes or the standards required by their employer and by their role. So for example, as we've set out on this slide, an employee doesn't meet agreed revenue targets, failing to meet work deadlines, poorly communicating with clients or colleagues. These are obvious performance management issues. And this will necessitate the usual performance management processes being applied, which will be more rigorous where an employee has access to an unfair dismissal regime. So as we know, we do go through a more granular process for those lower income employees. By contrast, misconduct issues go to behavioural concerns on the part of the employee, and sometimes those two can be conflated, where the way in which someone is interacting in their behaviour is dealt with as a performance issue, but it can sometimes be both conduct and performance. So misconduct issues go to these behavioural concerns, and that might be failing to comply with a reasonable direction, breaching their employment contract or a policy or a law. And really failure to comply with lawful directions is one to keep in mind, is because we sometimes see this characterised as a performance issue, when quite often it can be more appropriately characterised actually as a misconduct matter. So misconduct matters should usually be dealt with in accordance with your disciplinary processes rather than performance management processes. So again, it's just a distinction to reflect on when you've got these behavioural issues that might sit across both misconduct or performance. Now, I mentioned medical conditions because it's important to tread really carefully in the performance space with employees who have a medical condition, because it may be that their medical condition is impeding their ability to perform the inherent requirements of their role. And rather than there being a performance insufficiency or a misconduct issue. It might actually be a health issue. And of course, where there is a health issue, there might be a discrimination angle to it if someone has a mental health concern, for example. And so again, rather than putting someone on a PIP, you might be thinking, do we need to make reasonable adjustments as is required under the discrimination laws to ensure that this person can do their role having regard to their medical condition. So it's really important when an employee has a medical condition to have clear medical evidence in relation to their ability to perform the inherent requirements of their role, and to have a think about those reasonable adjustments. And I would just say, before moving on, that a really common thing that comes up in the context of performance management, where managers like to stick their head in the sand, is that there might be a mental health diagnosis. So the person's depressed, the person has anxiety, I don't want to talk to them about it because it's all too hard basket, or they're going through a tough time. We would, recommend against that. It is important that you deal with these things in a timely manner, acknowledging, of course, that there might be a medical condition that is hampering that person's ability to essentially affect, their duties. But I would say when you're talking to your managers within the business, that not to be scared of dealing with performance issues if someone has a medical condition, just to, of course, get support from HR so that you're not breaching any discrimination laws in the process. So in terms of effective performance management for workers, I've got this slide just as really a reminder of some of the key things to consider in terms of assessing whether someone is actually meeting their day-to-day performance. Because sometimes with a lot of people working more flexibly and remotely, out of sight can sometimes mean out of mind. And so it really is quite important that managers proactively manage their staff. And this is, of course, still the case when people are working remotely. So some of the measures that we recommend and that are quite common is obviously holding regular performance reviews, having discussions and getting feedback, setting goals, having expectations that are communicated quite clearly to staff, and really picking up on those performance management issues as they arise. And increasingly, we're seeing a move towards much more frequent and informal check-ins. And I think that really is something that the pandemic has focused on, because we're seeing the need to actually have sort of quarterly check-ins rather than just an annual performance review, so that you can catch any performance concerns and any behavioural concerns, before they might escalate. Because, as I said, it is much harder when people aren't in the office being observed all of the time. So some of the things, again, that we're recommending in the context of supervision is ensuring that there is this ongoing dialogue, having those discussions before they escalate, and then really trying to identify issues early, because really, probably the most common HR horror we see is that we will have an HR client call us up to say, look, business wants to terminate this person's employment. First question we say is, for performance reasons, we say, has there been any performance discussions? And, the answer might be no, or just informal discussions. So getting that rigor around the processes to have both informal and formal conduct and performance measures is really important. And as I said, having people physically out of the office makes that a lot more challenging, but it's something to remind your clients about internally, so that you're not dealing then with the HR horror of having to terminate someone for performance issues where there hasn't been a process that preceded that. So I mentioned that I wasn't going to talk too much about pandemic-related horrors, but I thought it'd be remiss of me not to mention returning to the office, because whilst most organisations have returned to the office, we are having, almost daily conversations with clients where the issue is, how do we get staff back to the office? People don't want to come back to the office. We've got people in a few days a week. Should we mandate? Should we not mandate? So it is quite a vexed issue now, even though the pandemic is, touch wood, behind us, because that flexibility that the pandemic introduced, continues to be relevant. So what we recommend is that in considering these matters, you think about, is it reasonable and lawful to direct staff back to the office? And essentially, if it's a reasonable and lawful direction, you will have the support of the law. And so I've included on this slide, I won't go through it in the interest of time, but I've included on this slide the considerations that the Commission will look at in terms of a direction to bring someone back into the office, because even though the pandemic is behind us, we really do have issues getting people back into their offices. So impact on broader team, the ability for them to do their job, all of these things will factor into whether that's going to be a lawful and reasonable direction for the purposes of any assessment that's made by the Fair Work Commission or another court. As I mentioned, managing performance improvement plans is really challenging. This slide really just talks about ensuring that you're meeting procedural fairness when you're talking about performance with staff. So of course there's going to be a performance improvement plan. You'll have that PIP document, ensuring that the document is really clear, easy to understand, and articulates the concerns will be important in terms of demonstrating that you have complied with the obligations to give staff procedural fairness. So really just going through the process quite delicately, ensuring that there's a support person, ensuring that they've got an opportunity to respond will be key in terms of minimising the HR horrors that relate to performance improvement plans. And again, this slide is just a reminder for you when you're communicating around performance improvement plans to essentially be able to focus on the key issues. So you've identified the performance issues, you've identified what the underperformance is, they've got an opportunity to respond, they've confirmed they understand the expectations. That's probably the most common area of concern where people don't quite get it, and that any concerns raised by the employee are taken seriously, and of course that there is also confidentiality around that process so that staff aren't, alive to the fact that their colleague is being managed. This slide I just included really again as a takeaway of what should be included in a PIP, because we in our roles see performance improvement plans from a lot of different organisations and are quite often surprised by the lack of information in there. So expectations, how it's going to be monitored, the process, the consequences of not meeting that performance improvement plan, and the timeframes are really important in terms of having a process that's going to be defendable in terms of the Fair Work Commission. So I wanted to mention this case very quickly that was in the Fair Work Commission last year, where we had an applicant that had been put on a PIP, they'd received a verbal warning and a written warning, and essentially they were not meeting their targets in terms of their sales revenue. And in this case, the employee, and this issue has come up quite a lot of us with our clients, the employee basically said, I couldn't do my sales role because of the pandemic. And essentially said that the performance improvement plan and the termination that followed was unfair. And so here we had the Commission find that there was a valid reason for termination. The unfair dismissal didn't get up, essentially because the benefit of a solid performance improvement plan that had predated the pandemic, as well as check-ins by the employer so that it was clear that they had managed that process, meant that the unfair dismissal claim was rejected and that it was found that the employee wasn't unfairly dismissed. I'm not going to go through this slide in the interest of time. I'm going to head straight to the case, because this is a case that sort of reflects how PIPs can sometimes be used in the wrong case, and that probably is the main HR horror. And in this case of Moretti and Hines, the employee had been there for 18 years, and went to a meeting and was basically told that there wasn't a job for him, and that if he didn't resign, he'd be put on a performance improvement plan and managed out of the organisation. Unsurprisingly, that employee found that that was unfair and applied to the Fair Work Commission to made an unfair dismissal application. Because he'd been terminated because he failed to comply with or participate in the performance improvement plan. And in that case, the Commission found, of course, that there was an unfair dismissal. The employer had been disingenuous in applying that PIP in those circumstances, and that it was clear that essentially the PIP was just going to be the first step of that employee being pushed out the door. So again, that's this case of Moretti and Hines is just a reminder that PIPs are, of course, an important tool, but sham PIPs, where everybody knows what the outcome is, are not a good idea. You're better off having a negotiated exit, cutting to the chase, rather than going through this process where everybody knows what the outcome will be. So the next case I wanted to talk about, again, relating to performance improvement, was a decision that was handed down in June this year. And it's a good reminder for employers not to dress up dismissals as something else, and to dress up dismissals for conduct or performance reasons. And I'm sure all of you have been involved in cases like this. But essentially, in this case, there had been some performance issues with the employee, but the employee was ultimately terminated for redundancy reasons. And the employee actually accepted that they were redundant, and notwithstanding the fact that consultation obligations hadn't been complied with, they went on their merry way. But in this case, the employer made the very silly move of wanting to have the last laugh and the last word on it. And after their employment had ended, sent them an email confirming actually they had terminated their employment because of the sustained performance issues. So unsurprisingly, that person then made an unfair dismissal complaint to the Fair Work Commission. It was out of time because more than 21 days had passed, but the Fair Work Commission allowed that complaint, notwithstanding it was out of time, and found that it wasn't a genuine redundancy, that procedural fairness hadn't been complied with, and that essentially these performance issues should have been the reason for the termination rather than a redundancy. So again, it's something that comes up quite often with our clients where they say, well, can't we just make them redundant? And of course, you have to test, is it a bona fide redundancy? Is it genuine? If the answer is no, and it's actually performance issues, then of course, we would prefer that they work through that process. And this is just an extract from the case where the judge has said, it appears that redundancy was relied on to gloss over having to deal with performance and conduct concerns in relation to Ms. O'Neill. Further, if consultation was required, it does not appear to have occurred. So double whammy for this employer, where they not only, terminated someone for a redundancy reason when it was performance-based, but then they didn't even actually comply with the consultation obligations that they had at law. So very, very silly employer. I'm sure none of you would let your organisations do that. The last case that I wanted to mention was this case that was handed down in December last year in the first instance, but then there was an appeal that was handed down just in the last few months. And this was a case where we saw the largest compensation award for a general protections claim. So general protections and adverse action are synonymous, and I'm sure most of you have had the displeasure of having to deal with them. But in this case, we saw a long-serving employee who had been harassed and bullied at work by the CEO of the organisation. And really, as a result of that bullying at work, so I said harassed, but it wasn't sexual harassment, it was just sort of general harassment at work. As a result of that harassment, she was awarded $2.8 million by the federal court following an adverse action claim. So it's a really significant, it's the highest compensation claim we've ever had in the general protections jurisdiction. So I just wanted to mention it because, very interestingly, her claim related to bullying, micromanagement, being undermined in front of other staff. So just classic bullying behaviours that led to her not being confident, led to an anxiety, and an actual claim that ordinarily would have been dealt with by workers' compensation or personal injury claims, which you might be aware there are monetary caps for personal injury and workers' comp claims, whereas the adverse action or general protections jurisdiction actually has uncapped damages. So here the court found that this woman had developed a psychiatric injury as a result of the treatment that she had in the workplace, and ultimately the club that she worked at was found to have essentially just overlooked the behaviours because it was the CEO who was doing them. So a $2.8 million claim is really huge for that type of claim that would ordinarily have these financial caps under the workers' comp and personal injury law. So it really does highlight the importance of dealing with these claims as they arise, whether it's a bullying claim or a conduct claim, because we are now seeing significant awards where there is this incapacity in a non-conventional jurisdiction, because as I said, it's not the sort of things that we would normally see coming up in an adverse action claim. So these are the key takeaways, I think, for today, focusing on, this last case that I just mentioned, workplace bullying. It's not just a small fry matter in terms of minimal damages that can arise. $2.8 million, the highest award of penalties in the adverse action space we have ever seen, has come about from workplace bullying. And it was things like micromanagement. Nobody was throwing things at this woman. It was just those little low forms of bullying that we do see, unfortunately, quite often in the workplace. So as you'd be aware, there is a focus on mental health. The safety regulators are looking at mental health as a significant issue. The cost of mental health in Australia is huge. Statistics show in 2020, 2021, 1 in 5 people, or 4.2 million people in Australia, have suffered from mental health in the last 12 months. And over 2 in 5 Australians aged between 16 and 85 have experienced a mental disorder. So again, being cognizant of these things and ensuring that people are safe at work, notwithstanding these mental health conditions, is really important in a world where we are now seeing close to $3 million being awarded by courts. So that's the workplace bullying side. Employee claims. I've mentioned some of the HR horrors that can arise in the context of poor performance management, underperformance and misconduct. But of course they include, unfair dismissals when the procedural fairness hasn't been complied with, adverse action cases where there's a reverse onus of proof on the employer in defending claims is another one that comes up, where again we have uncapped damages. And so really ensuring that these processes are complied with in a really granular way is important to minimise those risks. I've got up here investigating complaints because, of course, in the context of the positive duty, we need to ensure that allegations of misconduct are heard, that they're taken seriously, that confidentiality and impartiality is complied with. And oftentimes that might mean that we don't do an internal investigation, that we get an external organisation to run that process, to discharge that obligation that we have to keep people safe and to have that appropriate process. But of course, HR can facilitate that process by keeping open channels of communication with the complainant, providing clear timelines on the process, and ensuring that staff are essentially aware of their rights, and really having that respectful contact with the complainant so that they're seen to be supported through that process. And the last one, of course, I've got there is sexual harassment. Just as a reminder that silence is no longer the norm. We consider that there is a real shift in focus to proactive response, proactive prevention, and really greater transparency in this place, particularly considering, the positive duty, once the bill passes. So I'll stop there and allow some time for questions. I've run a little bit over, I see. Apologies. So as I
No,
said,
think
today was more of a deep dive into the HR horrors that sit with performance improvement. So any questions that come up?
I've got a question, but I'll come back to that in a sec. So one of the questions is about the mental health claims.
Yeah.
It's obviously hard and frustrating to deal with at times, but the question is, how does an employer deal with a suspect mental health claim? What are some top tips on dealing with that?
So it's a good one. So suspected means that we don't know that the person has a diagnosis. So knowing that they've got a diagnosis is always a double-edged sword, because once you know, that can be form the basis of a discrimination claim. But sometimes it's readily apparent that someone's not traveling well. So I think having open discussions, having the manager or the HRBP, saying, for example, I've noticed you're not traveling so well. Is there anything that we can do to help? You can't push the person to reveal a diagnosis, but if someone is essentially having performance issues, then sometimes that might mean that we essentially will recommend that they might be medically assessed if they're not willing to provide that information transparently themselves. But I would say the top tip probably in the mental health space generally is to not shy away from having those hard discussions. The stigma around mental health is really reduced. People are more open to talking about it at work, but sticking your head in the sand is always going to create more liabilities than not. So understanding what the condition is, seeing if there's any support the organisation can provide, but in circumstances where that mental health condition or diagnosis is actually preventing them from being able to do the inherent requirements of their job, not being afraid to terminate their employment, ensuring that you've got those mechanisms in place to minimise a discrimination claim, because it's not to say that you need to have someone sitting there doing a job that they're not actually discharging. So trying to actually be a little bit bold to have those honest discussions.
We've got a few questions coming in, so if we go a little bit over time and people need to drop off, goodbye, but we'll try and get through a couple more of these. We won't go too long over. I'm going to go in order, but some of them are going to jump around a bit. But what is there a minimum? Oh, hang on, my screen's moved. Is there a minimum time a PIP must last before they can dismiss?
There isn't a minimum time. I mean, really, it depends on the nature of the PIP. So if the PIP is just one thing, being respectful to your colleagues, you could have, a month. You really just have to, the PIP has to be long enough that the employee can improve or show that change in behaviour. So I would say, quite often a PIP is about 3 months, but there will be circumstances where a shorter time frame will allow that person to demonstrate the change. Of course, the challenge is that sometimes if it's behavioural, people can, of course, put on their best behaviour for a month. It's harder for them to do that for 3 months. So really, there's no minimum time frame, but the practical consideration is, are we giving the employee enough time to change, to learn, if it's target related, to hit those targets? So you generally wouldn't see it less than a month, but sort of more the 3 month mark is probably, more common.
Thank you. Coming back to managing performance with mental health,
yes.
What happens if somebody discloses a mental health issue during the performance discussions?
Look, I think, again, it does often come up, and it comes up sometimes as a genuine reason why someone's not coping or not performing their duties. Sometimes it does come up as an excuse where it may not actually be the reason for the poor performance. So I think if it comes up, then I think, essentially you want to have an empathic response. So either, well, we weren't aware of that, or alternatively, I had my suspicions that maybe you were having some mental health challenges, and then really you can either pause and say, do you think your depression, anxiety, bipolar is the reason for the performance issues? If they say yes, then probably the easiest way to navigate it safely is to say, do you have a treating doctor? Can we work with your treating doctor to help you improve your performance in a way that's going to be safe and manageable for you? And that's you essentially having that open dialogue and looking to see what supports you can give that person in conjunction with their treating doctor. And the treating doctor will generally will mean if the person's just raising it, it's not the true reason, that'll sometimes go away and they'll say, no, that's fine. I'll just be better. Actually, I can get into the office at 9 o'clock, each day. So it sometimes flushes out those, sometimes bogus excuses that people can give. I'm not suggesting that, sometimes people will say, well, actually, I've got depression when they don't. Of course, if the person is actually genuinely struggling, then you'll need to have that, dialogue to support them.
I think that answers another question we had, but another one is we've provided info on an EAP, allowed time off to attend psych appointments, but still not performing, failed a PIP, first warning with a final warning coming. Sorry, I've just got to scroll down a bit. I don't know if that's really a question or more just a bit of background, but
look, it sounds like next step, I would say in that case, it sounds like you've given that person all the supports that are standard and probably gone above and beyond in terms of the psych support as well as EAP and the PIP. So I would say that you're probably at a stage where you can get ready to terminate their employment on the basis that they're not meeting the inherent requirements of the job. So it's just important that in that process you articulate those inherent requirements that they're not meeting, because being able to demonstrate that they're not meeting the inherent requirements of the job is the way in which you can defend against a discrimination case, which if they have a mental health diagnosis, that is a disability claim that can be made otherwise.
And I think that does answer another question. Right, final one. What do you suggest when the victim is within HR? So it's very insular and hard to manage with the CEO who's close to the Chief People Officer.
Yeah, I had one of these recently. It's actually very hard. So the victim's HR, So quite often the general counsel or legal team can assist, but HR professionals are actually incredibly renowned for sort of toughing it out and thinking, why can't I just deal with this myself? So I've seen it go very badly where they've tried to handle it internally. Sometimes I will actually say, is there a hotline to an external provider? That might be the way in which you manage it. But I think essentially treating it in the same way, but noting that person is going to know all the rules and how things work. HR professionals and employment lawyers are the hardest people to have in claims because they know all the tricks in the book. But I think it does add a degree of challenge, and sometimes that might be bring in external support of an employment lawyer to manage the process externally, because the person that would otherwise normally run that function is actually the victim in the complaint. So trying to leverage external support is the sort of safest way, especially where it's involving, the C-suite and the HR, which it's not uncommon actually to have that arise, unfortunately.
Wonderful. I think that's it. We've covered a lot of ground. Thank you so much, Cilla. Always
worries at all.
To have your, amazing tips on getting those sort of basics right.
Yeah. Well, if there's any other questions, I do have some contact details in the slide, so happy for you to reach out if there was a burning question that you had that we didn't cover. I apologise. We were running through things relatively quickly to get through all the content.
And I think we should be able to get those slides out either this afternoon, Cilla, or tomorrow morning. Yep. So we can get that done. The recording gets topped and tailed, and subtitles and stuff go in. So once that's all made to look pretty, we'll get that out, which is usually about a week. But look, I hope it's been useful. As Cilla said, do reach out if you've got if your organisation needs any help on any of these kind of issues.
Yep.
But also keep an eye on the LinkedIn Fraser Jones page, and we'll be emailing you as well. We've got some events in the pipeline for next year as well, and hopefully Cilla will be back next year for another HR horrors in time for Halloween.
There'll be some more ones.
Yeah, I'm sure. I was going to ask you what you think you're going to see next year, but we'll save that for another time. Given the time of day, we'll let everyone get on their lunch with their lunchtime email catch-ups. But yeah, thank you everyone for joining, and have a good rest of your day or evening, depending on where you are in the world. Thanks, Cilla.
Thanks, Angela. Thanks, everybody. See you later.
Yeah. Bye. Bye.